Hey there. Today I want to talk to you about the surveillance era that we are entering, some strange things I've seen the government start doing, and a new piece of legislation that's been introduced by the Mark Carney Liberal government. This is Bill C-2. Bill C-2 is going to have some sweeping implications on privacy, and we at the Canadian Constitution Foundation have released an analysis with some of our big concerns, which you can read at the ccf.ca. But I'm going to give you the highlights here, and I'm going to talk about the expansion of the surveillance state, why privacy matters, and what you can do to better safeguard it. And the most important action that you can take is learning about your privacy rights. And to help you do that, we've actually created an online course on state surveillance that you can take totally for free at the ccf.ca/learn. If you do sign up for the free online course, let me know by leaving a comment below and what you think of the course. Please sign up. We really want people to learn about their privacy so that they can better protect it. Okay, so let's get into why privacy matters and what our governments have been up to lately to undermine it. I can't wait to tell you all about it. If you're new here, welcome. My name is Christine, and I'm the litigation director at the Canadian Constitution Foundation, a legal charity that fights for fundamental freedoms in Canada. I upload regular videos about our ongoing legal cases and about other interesting developments in constitutional law in Canada. So if that sounds like something you'd be interested in, please hit like and subscribe below. It really helps my videos out a lot. Also, please remember that nothing in my videos is ever legal advice. If you have your own legal question or problem, please consult your own lawyer. Okay, so today I want to talk about the expansion of the surveillance state, why privacy matters, and how you can protect yourself. So first, privacy protects the most fundamental aspects of human dignity, freedom, and security. It allows you to decide what information you share about yourself, with whom, and for what purpose. Privacy is a protection against abuse of power, and with unchecked access to private information, governments and even private companies can surveil, manipulate, and discriminate against people. Privacy is a safeguard of basic freedoms. It creates a space to think, protecting dissenting voices from unpopular opinions. So people are more willing to speak freely, to protest, or to associate with other groups when they know that their activities are not constantly monitored and surveilled. Privacy rights aren't just about keeping secrets. They're about maintaining freedom, fairness, and dignity in a world that we live in now where information is power. In Canada, we have statutory as well as constitutional protections for privacy. In our Constitution, specifically Section 8 of the Charter, guarantees the right to be free from an unreasonable search and seizure. And this also protects against unreasonable searches of information like bank records, phone call logs, or a government official snooping through your mail or cell phone photos, just to give a few examples. But I have been really concerned about a few things I've seen lately that will have big implications for our privacy rights. I'm going to start with this new piece of legislation from the Mark Carney government, Bill C-2, which is also called the Strong Borders Act. And it's one of the first pieces of legislation that this new government has introduced. And look, strong borders are important. I totally agree. And this law is in theory aimed at fixing real problems, like reducing the amount of fentanyl that we are seeing coming across the border, and which is harming our communities. And this is something that's important to address, not just because so many Canadians are being hurt by fentanyl, but also because this fentanyl crisis is part of Trump's argument for limiting trade with Canada. So we really do need to address fentanyl and secure our borders. But we need to do it in a way that ensures that law-abiding Canadians do not have their privacy rights violated. And that is what C-2 risks. Millions of Canadians could lose fundamental privacy rights as Parliament pushes ahead with this bill. The legislation would give police and CSIS, our spy agency, unprecedented surveillance powers without proper judicial oversight. So we did an analysis of this law, and we've identified multiple parts of C-2 that implicate the rights of Canadians under Section 8 of the Charter to be secure against an unreasonable search and seizure. And these include provisions that enlist financial institutions like banks in snooping through your records, new powers to open letter mail without proper safeguards, allowing police to demand information without a warrant, and powers that enlist electronic surveillance providers in secret spying. So let me go through all of these. So there is a proposed secret spying software regime. So Part 15 of Bill C-2 would create a new statute called the Supporting Authorized Access to Information Act to govern what is known as lawful access. This statute would give CSIS and police powers to obtain information from electronic service providers, which are defined as any service that involves creating, storing, transmitting, or making available information in electronic or digital form. So it includes things like WhatsApp, Gmail, and TikTok. And the statute would allow a cabinet minister to make secret orders to install devices or software to collect information. And service providers could be fined for publicly disclosing the details. So according to one expert who's done an analysis of this proposed legislation, Professor Robert Diab, the act would give the minister in charge the power to define by regulation the meaning of any term or expression for the purposes of the act, including authentication, encryption, systemic vulnerability. And there is a possibility that the government could create a so-called backdoor that would allow spy agencies and police secret real-time access to data. And we're concerned that innocent Canadians might face warrantless searches of their private online data in violation of Section 8 of the Charter, and that service providers would be prevented from even disclosing this to users and to the public. The legislation, or the proposed legislation, also has a problem because it enlists financial institutions in warrantless searches. Part 16 of the bill would amend the Proceeds of Crime and Terrorist Financing Act, which is our money laundering legislation, to allow the RCMP or other agencies to write to financial institutions to warn them that a person may be committing terrorist financing, money laundering, or sanctions evasions. The law would then enlist banks into the collection of information about that person without their knowledge and would prevent them from being tipped off that they are suspected of a crime. And we are concerned that this could lead to routine use of warrantless searches. Then there's this strange provision in the bill that bans large cash deposits. Part 11 of the bill would amend the Proceeds of Crime and Terrorist Financing Act to ban most businesses, with a few exceptions like financial institutions, from accepting payments, donations, or deposits of $10,000 or more in cash. So paying for items in cash is more private than paying for them electronically because the electronic payment system creates a digital record. You know, cash is valid currency, and we are concerned that this ban on cash could be a slippery slope towards a broader cashless society where governments can more easily monitor how we spend our money. Then there's Part 4 of this bill that grants this new power to open mail. The bill would allow Canada Post to open letter mail, not just parcels, if there are reasonable grounds to suspect that a letter contains dangerous goods or contraband. Now, opening letter mail would certainly be a more vigilant monitoring process to reduce the amount of fentanyl harming Canadians, but the problem is there are no safeguards built into this bill to prevent a Canada Post employee from reading private letters. This needs to be fixed. So, for example, the act could restrict employees to only opening letter mail under video recording or requiring that a copy of that video be provided to the recipient of the letter to show that their private letters were not also being read by employees. There is also a concern we have about warrantless information demands. Section 487 sub 0121 of the bill would allow police officers to demand that anyone who provides service to the public to hand over subscriber information, including whether that person provides or has provided services to a particular person or account, dates when the services were provided, the country, province, or municipality where the services were provided, and whether the person is in possession of other information related to those services. In order to do this, police would require reasonable grounds to suspect that an offense has been committed, but they would not need authorization from a neutral third party like a justice to confirm that a reasonable suspicion exists before making the demand. The person or business receiving the demand would face a $5,000 fine if they do not hand over the information, and they would only have 5 days to file an application asking a judge to review the request. The definition of service provider is also so broad that this could allow police to demand to know whether a certain medical provider has treated a person, whether a particular dating app provides services to a person, or whether a person has donated to a particular cause on GoFundMe. We at the CCF are concerned that the warrantless information demands process is not tailored enough to prevent snooping, and that the 5-day deadline for challenging the demand is way too short and onerous. There are also voluntary information demands outlined in Part 14 of Bill C-2. That section states that police do not need judicial authorization to ask a person to voluntarily provide information. And as that professor I mentioned, Professor Robert Diab, has pointed out, the Supreme Court has already said that Parliament cannot render these sort of searches legal by just declaring so in legislation. If a person has a reasonable expectation of privacy in the information, this may be a warrantless search. And we're concerned that this section will cause an unsophisticated information holder and law enforcement agents to believe that warrantless searches have been greenlit when such searches actually violate the Charter. All of this needs to be fixed in order to better protect the privacy rights of Canadians, and also to ensure that we do have secure borders. You don't need to give up your privacy in order to have security. My concerns about privacy don't end there. I have privacy concerns at every level of government. It isn't under threat just by the federal Carney government. Provincial and municipal governments are taking their own actions to undermine privacy as well. For example, in Kingston, the police are ticketing drivers at red lights for merely touching their cell phones based on evidence that they collect with a drone flying above red lights at traffic stops. There was also a case recently heard at the Supreme Court that I've talked about on this channel about police entering a private driveway, not just looking in a truck window, but looking in the window at this private home, opening the door, and then collecting evidence, all without a warrant. The Alberta's Court of King's Bench also just considered a case involving facial recognition technology from the company Clearview AI. We know that during the COVID-19 pandemic, the Canadian government was tracking cell phone location data of 33 million Canadians to ensure we were doing our part and staying home. And who can forget when the Trudeau government invoked the Emergencies Act and ordered the freezing of bank accounts of people on a police-compiled blacklist of protesters that was distributed by the government, all sent to all of these different financial institutions and even actually sent to some lobby groups. What all of these cases demonstrate is that we have entered the era of mass surveillance, and our current legal protections are not enough. Our privacy legislation is very outdated. Privacy Commissioner Philippe Dufresne has said that we are at a pivotal time for privacy rights in Canada. Former Ontario Privacy Commissioner Dr. Anne Cavoukian has called for updates to Canadian privacy laws so that they apply to all data, including anonymized data. Much has changed since the federal privacy legislation was drafted in the 2000s, but efforts to modernize that federal law died when Parliament was prorogued by Justin Trudeau. But instead of introducing legislation to better protect privacy, Mark Carney introduced Bill C-2. Now, when it comes to state intrusions, another issue that I have is that the concept of a reasonable expectation of privacy may be inadequate. So a lot of the Supreme Court jurisprudence around Section 8 of the Charter deals with a person's reasonable expectation of privacy against a state intrusion. And the notion of a reasonable expectation of privacy has sort of become a mantra in the jurisprudence. But some academics have said that in the era of mass surveillance, this guiding principle is actually an inadequate gatekeeper. Now, at the beginning of this video, I mentioned that we've just released a free online course so that you can learn about state surveillance and your privacy rights. You can take that course, which is taught by some of Canada's leading scholars at the ccf.ca/learn. Just as an aside, please go and sign up. We worked really hard on this course, and we have a number of different courses, and we've had a lot of people sign up for our free speech course. But there has actually been a lot less interest in our privacy course. And as I explained, without privacy, you're under constant surveillance of Big Brother. And as a result of that, many people do not feel like they can actually exercise their free speech rights. Your ability to exercise your free speech depends on your ability to be free from surveillance and monitoring. So please go sign up at the ccf.ca/learn. I promise you're going to learn so much. For example, we have a lecture from Rhodes Scholar and Osgoode Hall Law professor Francois Tanguay-Renaud. He was actually my criminal law professor in law school. And he proposes this crazy thought experiment that sort of reveals the inadequacy of that notion I was talking about, reasonable expectation of privacy. What if the police were recording people on the street with drones that follow people, record all of their movements as they go about their day, zooming in on their cell phones, recording their conversations while they walk down the sidewalk? So in this scenario, these people are in plain view. And in that case, reasonable expectation of privacy is an inadequate concept to limit what we kind of all would see intuitively, being monitored by a drone recording every action you take in society. We would all see that as oppressive state concept, but reasonable expectation of privacy is an inadequate concept to prohibit that type of conduct. At one time, I remember having drinks with Professor Tanguay-Renaud, and he gave me this theoretical scenario. And when he proposed it, I thought, at the time it was a little far-fetched. But today, it's so eerily similar to that Kingston drone case where police are using a drone, a high-accuracy drone, to take aerial images, peering into cars and zooming in on cell phones. Those drivers do have a reasonable expectation of privacy inside their cars, but what would limit the police from doing this if they were just walking up around on sidewalks or in the parks when they're in plain view without that reasonable expectation of privacy? A principled line needs to be drawn between things done in plain sight that police can view and constant surveillance being used with this enhanced technology. And I do not know if it's possible to draw that line on the basis of the existence or not of a reasonable expectation of privacy. There are other values that could serve as guiding or informing principles for Section 8. There's nothing in the text of Section 8 that mandates that the gatekeeper of the right be reasonable expectation of privacy rather than another interest like dignity, liberty, security, anonymity, public confidence in the administration of justice, or many other principles. And in American jurisprudence, the courts have actually been moving away from the concept of a reasonable expectation of privacy as the sole guiding principle for their privacy protections in the Fourth Amendment. So I think that to meet the challenges of the surveillance era, it is well past time for Parliament and provincial legislatures to update privacy laws. But as recent conduct has shown, it's time for our Section 8 jurisprudence to be revisited as well. And that can help to meet some of these emerging challenges of the surveillance state. And you can do your part by, for example, writing to your member of parliament about some of your concerns about Bill C-2. You can notice when you are being surveilled if it's by your municipal police force and talk to your municipal councillors. And to inform what you say and observe, please take our online course on privacy at the ccf.ca/learn. Okay, that's all for this update. Thanks for watching, and let's keep fighting for freedom in Canada.